I agree with the state. If you're asking me if this is a sympathetic case, it's extremely sympathetic in that we have a circumstance here, at least as far as we understand it, where perhaps a terminally ill or either, somebody who's either terminally ill or facing long-term care, is on life support, is in pain, is wanting to die. The law in the state of Florida does not allow for a mercy killing. What we've described here today is somebody purchasing a gun or ammunition, taking it into a hospital room with a plan, the plan being to take the life of another person and take her own ultimately. I don't get to question the law. I don't get to apply it in my own special way. I have to follow the law. That's what I do. And under Florida law, that is premeditated murder. So when we look to the bond statute, basically, pretrial release is a situation where somebody's entitled to bond unless they're charged with a capital offense or offense punishable by life, which is clearly what we have here. And if the proof of guilt is evident or the presumption is great. The evidence before this court is that when the decedent is shot, she's the only person in the room with them. She's the person who has the gun. She's the person who purchased the ammunition. And by her own admission, she's the person who held the gun to his head and shot him. Again, albeit tragic, this is not a situation where two people at home have made this decision, which would still be illegal, but made a decision to take a life out of mercy. Unfortunately, we have a defendant here who chose to walk into a hospital, the loaded firearm, and a lot of ammunition, not just 2 bullets, I have to point out, take the life of another human being, her husband, and unfortunately went from there to what I understand to be an hours-long standoff, during which she points a gun at a nurse, she points a gun at a hospital security officer, and ultimately points a gun at some police officers and shoots, at least in their general direction. Fortunately, she did not hit them. I can appreciate that Dr. Danziger is saying that he feels that due to time, she's not in the acute situation that she was, and therefore no longer a substantial risk of harm. But this occasion occurred just on January 21st. Today's February 10th. So we're not even 3 weeks out. Dr. Danziger, and no disrespect to him, of course, did not consider the police reports at all. I guess he listened to some media outlets, but the reality is the best evidence, of course, would be the police reports and making a determination as to how dangerous somebody may or may not be to the community. I find that the reports provide a lot of information. Her shooting at police officers is a very significant fact that I don't believe he knew. I think I wrote down 45 live rounds. To me, it's a very significant piece of evidence. I don't know the specifics of this particular wing other than its long-term care, but I do know that if somebody wants to discharge themselves from a hospital after the court order, I don't know that you can't do that. But in this situation, unfortunately, they chose to do it in a very public manner on a floor where we have other people facing long-term care or terminal illness. And as the state points out, family members, staff members, people going about their business, trying to provide care and trying to help people. And what they have is somebody who brings a gun onto the floor, into the room, shoots in the room multiple times, points the gun at many people, threatens to shoot them. I am finding that the state has met the burden. Proof of guilt is evident, and the presumption is great, given that she's the person in the room, she's the person who purchased the ammunition, she's the person who admitted to it and described the actual act, and she's the person who pointed at and shot the gun after the death of the decedent. I am going to find that she is a danger to the community based on that behavior, so I'm denying the motion. I'm sorry. All right. Anything else from council?
Thank you.
All right, thank you.